Supreme Court of India dismissed the appeal in the matter of LAKHANI Housing Corporation Private Limited versus State of Maharashtra and said that the appellants have no locus standi to challenge the e-tender in a writ proceeding when the redevelopment of the said land is carried out as a clustered development scheme under the DCPR, which enables the Maharashtra HADA jointly with the landowners cooperative societies to carry out such development. The question for consideration in this case was whether the e-tender issued by Maharashtra Housing and Area Development Authority in pursuance of a cabinet decision followed up with a government resolution interferes with the contractual rights of the appellants. In a writ petition filed by the appellants before the High Court of Bombay, initially, stay was granted on the fundamental question of jurisdiction of MHADA to proceed with the cluster redevelopment in a land having an extent of approximately 11.20 acres, commonly known as Guru Tegh Bahadur Nagar, which is not owned by the state and lies as a freehold. The division bench of the High Court finally dismissed the writ petition, in which judgment is impugned in the present appeal. The High Court of Bombay noticed that the land once had 25 buildings standing on it, housing around 1200 families, the allotment having originally been made to the refugees from Pakistan. The buildings were 62 to 66 years old, standing in an extremely dilapidated condition, classified as category C1 by the Brihan Mumbai Municipal Corporation, which stood demolished in the year 2019 after proper notices were issued and proceedings taken under the BMC Act. The appellants had approached the residents in a said building for redevelopment of the land and, as per the claim, obtained agreements for redevelopment from individual members. Appellants had also spent around rupees 17.31 crores in pursuing initial steps for redevelopment. However, redevelopment project did not fructify, according to appellants, since the residents did not have proper title deeds, despite sanads being executed in their favor between 1954 and 1987. It was the appellants who took steps to ensure proper conveyances executed by the President of India to be issued in favor of the families, the absence of which was the only reason for the development of land having not been taken up. It was contended that the MHADA could not have intervened with an e-tender based on the government resolutions, the government having no rights over the land since the property was privately owned and did not belong to the state. Court said that appellants have failed to show us any vested right to carry out the development, especially when there is not even a registered agreement with any individual or the societies. The very claim of the appellants, based on the resolutions purportedly of the societies, clearly indicate that the promises made by the appellant were not complied with, and the redevelopment also was not carried out within time stipulated, leading to the breach of any such agreement, if at all such agreements were valid and enforceable. Court said that appellants have asserted that they have spent about rupees 17 crores, which is not a matter to be merely asserted on affidavit and requires substantiation by proper evidence adduced in the civil suit. Here, it is also pertinent that the division bench of the Bombay High Court found that even if the expenditure of rupees 9.5 crores disbursed as corpus fund is accepted, looking at the amount entitled to each of the occupants, only 217 persons would have been paid the said amount out of a total of 1200 persons. Court said that we have already found that the expenses asserted by the appellants in pursuing the agreements have not been substantiated in the writ proceedings, nor have they established that it is by their intervention the conveyances were facilitated. Appellant may have a remedy against the individuals or the societies, but the writ petition cannot be maintained as against the e-tender issued by the MHADA, especially when the societies in one voice support the development initiative of MHADA, which is a joint venture as permitted by the DCPR.